The former President Jacob Zuma has withdrawn his constitutional court bid to appeal the dismissal of his stay of prosecution. His foundation says this paves the way for him to prepare for his trial and demonstrate that he's never benefited from any arms deal corruption. Let's discuss this further. We're joined by Newzroom Afrika's editorial contributor, Karyn Maughan. Karyn, good evening. Remind us again, why was the former president before the Con Court to begin with?
Well, basically here, Kathy, what had happened was, of course, 3 judges in the Pietermaritzburg High Court dismissing last year the former president's application for a permanent stay of his corruption prosecution on the basis that it had been unduly delayed and was tainted by profound political interference and manipulation in its processes. He then attempted to appeal that decision, was turned down by the High Court, was turned down by the Appeal Court, and then went to the Constitutional Court. However, given in the last few weeks, it emerged that he has fired his previous attorney, Daniel Mancha, and now replaced him with Eric Mabuza, the first major decision being taken at this point to withdraw that Constitutional Court appeal, and as you rightly point out, essentially paved the way for him to go on trial as early as this year.
Of course, it's interesting because in the statement that the foundation has issued, it says that Zuma appreciates the support he's been receiving, but it hopes that citizens will finally get clarity and closure on the real beneficiaries of the arms deal, if any corruption in that regard did even occur.
Well, I mean, this has been a contention that the former president has raised throughout his permanent stay of prosecution application. He contends that, it was inappropriate for him to be charged with so-called arms deal corruption because, in fact, he played no part in the arms deal, and that the key piece of evidence that was used to convict his former financial advisor, Shabir Sheikh, of corruption, that 2001 letter which Zuma had signed, effectively saying that the Standing Committee of Public Accounts at Parliament should not seek an SIU investigation into the arms deal. Of course, the SIU would have been able to cancel any arms deal or contract, demonstrated that Zuma had actually acted on a 500,000 rand bribe procured for him by Sheikh to protect French arms company Thales from an investigation. Zuma has maintained throughout that while he signed that letter, it was in fact written by Thabo Mbeki. And he seems to be suggesting that his trial will really be a conduit for that kind of revelation and those kind of claims to be articulated by him as defense to the charges that he now faces.
All right, Karyn, we're going to get a little bit into the speculative realm, but in as far as when a trial date is likely to be set down for, we know courts are offering very limited services. Is it likely that this case will be heard this year?
Well, former President Jacob Zuma is due back in court on the 6th of May. Of course, that contentious issue about the suspended arrest warrant that is over his head will have to be ventilated and decided upon when and if he does return to court. But Kathy, French arms company Thales representative Christine Gouvier will not be able to be in South Africa for that court appearance. And given that France, there's no possibility of international travel at this point, that will be a pivotal factor that determines what happens. Also very important, Thales has lodged a constitutional court appeal which is premised on its argument that then NPA head Sean Abrams was wrong to join it as a co-accused with Zuma. Now, given that the courts have already twice rejected that kind of contention, it is unlikely that the Constitutional Court will hear that appeal, but for this case to proceed, there will need to be a definitive decision taken on that matter. Having said all that, COVID permitting, there is a very distinct possibility that the former president and Thales will be in the dock this year.